Hi, I'm Ronald. I'm a lawyer, advocate, educator, speaker, writer, thinker. In this episode, I examine patents. What are patents? Patents are monopoly rights granted to inventors for inventions that are new, novel, involve an inventive step, and are capable of industrial application. Inventions can be products or processes that would not include discoveries, theories, or literary works. Now, rights consisting in a patent are only obtained on application by an inventor to a relevant authority under relevant legislation. Now, who is entitled to the grant of a patent? The default position is that the inventor is entitled. That doesn't mean that the inventor must have the technical capabilities to make the invention functional. However, the rights may vest in a third party if the inventor agreed with the third party that rights developed by an inventor in the course of a particular project shall vest in such third party. An applicable rule of law, including foreign laws, could provide for a third party to be entitled to such grant. An invention is created by an employee in a course of employment, however, would generally vest in the employer, although is subject to an alternative arrangement. Generally, the validity of a patent can be subsequently challenged for not meeting requirements of the patents legislation. For example, it lacks novelty, it's not new. Or somebody can actually apply for the revocation of another person's patent on the grounds that it is not patentable or granted to a person not entitled to such a grant. For an invention to be treated as new, it must not form part of the state of the art for the invention in question, not found in materials that are available or accessible to the public, and it must not be anticipated by any pieces of prior art prior to the invention. So that's why practically it's important not to disclose inventions publicly before patent applications have been validly filed. That's why it's also important for inventors to have confidentiality or non-disclosure NDA agreements when sharing about inventions. Now, for invention to be treated as an inventive step, it must not be obvious to a person skilled in the art, having regard to the relevant state of the art. And for an invention to be capable of industrial application, it can be any industry. Now, patent owners would have exclusive rights to do certain acts in relation to the invention, and doing the same without a valid license would amount to infringement. So examples of prohibited acts would be, with regard to products, making of the product, disposing, offering to dispose, or rather to supply or to use or to sell, import or keep the product, and for processes to use the process, uh, disposing of or using of the product obtained directly by means of the process. Now, if there's patent infringement that's being alleged, it could give rise to a lawsuit or a claim, a civil proceedings, and the claimant can seek several possible remedies. One would be an injunction, a court order restraining the infringing party from continuing infringement. Two, damages, monetary damages, compensation for loss suffered, or an account of profits, that's recovery of profits enjoyed by the infringing party in relation to the infringing product, or a delivery or destruction order, or a declaration that there is indeed a patent and that there is an infringement of the patent. Thank you. Be smart, be brief.